usually in the areas of death, incapacity, or disability. So it's never anybody's favorite topic, but it is something that we all face at one time or another. And as with most things in life, it usually goes better if we do a little bit of planning. So today, in the next hour, some of the issues that we face in this area, some of the tools we use, the main tools we use to deal with those, and then we'll touch on a few of the hot topics. I do allow you guys to ask questions as we go along, and I'll also have about 5 or 10 minutes usually at the end where you can ask questions. So anything that I didn't get to or didn't cover or that you came here to hear about and didn't hear about, we can do those at the end. Along the way, you can do questions as well. Just put them in the chat box and I'll keep an eye on it. Do the best I can to answer those as we go, okay? So when we talk about this kind of stuff, there are 3 main problems that we face in this area, okay? And they are probate, estate taxes, and incapacity or disability. And I'm going to touch on the estate taxes first because I think it'll be a pretty short topic. I do ask a fair amount of questions, by the way, so feel free. You can answer in the chat box as well. It kind of helps us have a little bit of back and forth so you guys don't fall asleep on me. So who can tell me how much are you allowed to leave right now today in the state of Colorado without paying estate tax? Anybody have a guess? $4 million. That's a good guess, Erica. It's actually more than that, okay? So the federal law, which is nationwide, the federal estate tax, the limit this year is actually 13, and I think it went up to 13.5 million. So it was indexed for inflation a few years ago. Obama set it at 5 million, indexed it for inflation, and then Trump doubled it, and it is still in effect as of today. So right now it's about 13.5 million you're allowed to leave without paying estate tax. How many people are over 13.5 million? Anybody raising their hand? I would not expect that. I'm not over 13 million. I'm just raising my hand by example there. I would need to be talking and Zooming with about 10,000 people on average to have one person raise their hand and be over 13 million because 99.99% of us are below that limit. So the vast majority of people don't have a problem with it. So why do I bring it up? Well, they have changed the estate tax limit 21 times in the 28 years that I've been practicing. It's been as low as 600,000. It was as low as $1 million as recently as about 8 years ago. And it is actually, they've tried to change it back to $1 million 3 times in the last 3 years. So if they were to change it back to $1 million, it includes everything you own when you pass away, including life insurance. So it would put a lot of people over the limit. So keep an eye on that. As of today, most of us probably don't have a problem, but you do want to be aware. Colorado currently has no estate tax. Ours expired about 8 years ago, and we have not enacted a new one because of Tabor, our constitutional amendment that says no new tax on the people without a vote of the people. That's right. Erica's on it. So right now, we don't have one. About 30 other states do have one. At some point, we probably will, but right now we don't. Okay, so you don't have to worry about it. Second problem, though, is a much bigger problem. And that's probate, okay? Everybody hates probate. Everybody's worried about how do I avoid probate? But probate's one of the most misunderstood things out there. What is probate? Anybody have an idea what it actually is it? I can tell you it's not a tax. It's not a trick by the government. What is it? Well, probate is the process of getting whatever's in your name out of your name when you pass away and getting it wherever it's supposed to go. Originally, wills started about 1244 AD in England with the Statute of Wills, and that was actually designed by the king for a special reason. And everyone thinks probate is to protect your family and make sure they get what they're supposed to get. But it's also to protect the government because they don't want your assets to be sitting there and not in circulation and in the economy, generating money, income, and value, okay, and production. And so in 1244, the king would come and say, well, I want to go fight the Crusades. I need gold. So they would send the tax guy to knock on the door, and people would answer the door and go, hey, the owner died. We don't know who's in charge. We don't have anybody to pay the tax. And the king would get very frustrated. And so they passed the Statute of Wills that says there's an orderly procedure, takes place in the court, in the county where you live when you pass away. So in America, we've been following the English system of laws for the last 250 years. So we have probate courts. They used to be called chancery courts in England. Same concept. It's a supervised process to make sure things get where they're supposed to go. If you have a will, we submit your will to the probate court. The judge looks it over, makes sure it's valid. If it is, they issue an order appointing your executor, or in Colorado, we call it personal representative. They go out, gather up all your stuff, pay off your debts, and distributes whatever's left according to the terms of the will. If you don't have a will, we do pretty much the same thing, but we follow the state statute. It's called the Colorado Probate Code. It's about 400 pages. And like most statutes, if you ever try to read it, it's not that fun. Sometimes, even if you know what you're doing, it's still not that fun. So if you ever hear the term, oh, I got a legal opinion from a lawyer, the reason you get that is because when somebody goes and says, hey, what's the answer to this question? You go to look it up in the statute. Like I said, there's usually about 20 to 25 sections of the statute that you will have to refer to and kind of cobble them all together to get your answer. And depending upon how you interpret each section, that could change your answer. And depending upon which sections you look at and which ones you don't, that could change your answer. So when you get a legal opinion from an attorney, that's their opinion based on what they researched. Well, guess what? You can go to a different attorney and get a different opinion. They could read certain sections differently. They could look at different sections and say, oh, you didn't include this section. That changes the answer. And you didn't read it this way. That changes the answer. And so, of course, eventually, we usually get on the same page and go, oh, yeah, that one you missed. Now you know, and now, okay, it's okay. But sometimes they say, nope, I disagree with the way you're reading it. And guess what? We call that litigation. Litigation, you go to court and you say, Your Honor, we think it's this way. They think it's that way. You tell us which way it is. And that's how you end up in court in front of the judge in litigation, okay? So one of the goals of course, of estate planning and elder law is to not end up in litigation because it's terrible, takes time, costs money, it's embarrassing, stressful, all of those things. And so when we talk about planning on probate, yes, we'll talk about how probate works and that your will is part of probate, but it's better to have a will than not have one, because if we go to the statute, it leaves more things open to interpretation, more things to argue about, more things that are equal priority for everyone involved. And so they all have their opinion about how it should go. And so you've got more things that can go wrong, and it's going to be more expensive to go iron them all out in court, okay? So that's what probate is. It's not a tax. It's not a trap. It's not a trick. It's not the government trying to get you, but it is a court process. And like most of those, they take time and cost money. In Colorado, we have what's called simplified probate, which means you probably won't find an easier or cheaper probate anywhere else in the country. That said, on average, they take about 9 to 18 months. I do about 50 a year. Easy ones are, in the 9 to 12 month range. Average ones, 12 to 15 months. I've got ones going on for 3-4 years sometimes, depending upon what's going on. And they start at about $12,000 to $15,000 and go up from there. The more time it takes, the more things we have to argue about, the more problems we have, the more expensive it gets. We're pretty reasonable. There's downtown firms that will charge $100,000 to do this. It's not a fun process. It takes time. It costs money. People don't enjoy it. So we're going to look at some of the ways that you can avoid probate and how to do all that, okay? But the third problem is the one I want to spend a little bit more time on, and that's incapacity or disability. How many people have known somebody who was legally incapacitated, or you yourself have been legally incapacitated according to the laws of the state of Colorado? How many hands? I can only see 6 hands, but let's see here. You can also, I think there's a little hand button you can use on your chat thing. No hands. Oh, there goes 1, Carletta. Okay. 2, Georgia. All right. I should see every hand in here. Why? Next question. Was anybody in here born 18 years old? No. Okay. If we're under the age of 18, what do we call that? We call that being a minor, right? That's right. That is one type of legal incapacity. You are not allowed to own property. You are not allowed to make your own decisions. Who does that for you? Your parents, right? Who are your legal guardians. That's right. Erica's on it. So the guardian is the person when you have parents and they're your natural parents, they are your guardians until you turn 18. Okay. You can also have a guardian if someone else needs to become the guardian. And one of the ways that happens, that's what we call elder law. And that's, as you get older, they're doing a better job of keeping us alive longer, but not always in tip-top shape. You have a stroke, heart attack, develop Alzheimer's, dementia, fall off a ladder and hit your head, car accident. You might end up legally incapacitated where you can't take care of yourself and you can't manage your own assets. If you don't have a plan and you didn't give people the power to help you, then the default is we go to court for guardianship, just like for a child, and we go to court for conservatorship. The guardian takes care of the person, the conservator manages and conserves their assets to make sure they have enough money to survive for the rest of their life, okay? Those processes take place in the same probate court before the same probate judge, and they also cost about the same, about 12 to 15 grand each for a basic one. And then they go up from there. If anybody argues over who's in charge, how you're cared for, how your assets are being invested, or how they're being spent, it will go up from there. And the fun part about guardianship conservatorship, it goes on every year for as long as you're alive. So we can only die once, and it can only go on for about a year, year and a half, right? Yeah, but guardianship conservatorship can go on 10, 15 years, okay? Happens all the time. So one of the things we look at when we're doing planning, and one of the reasons elder law started, which didn't really exist 20 years ago, we started coloradoelderlaw.com back in 2002, so 22 years ago now, and we were one of the first people to do elder law. When I started 29 years ago, it didn't exist. But it's one of the fastest growing areas of the law, and it's what happens if we can't take care of ourselves and we can't manage our assets. Who's going to pay for it? Who's going to be in charge? How are they going to take care of us? All of those different things. You may have a plan. Oh, I've got long-term care insurance. Or you may have a child who can help you, but they have to have the tools to do it. If you don't give them to them as part of your planning, the default is they have to go to court to get those tools. That's called guardianship and conservatorship. Okay? So you're all saying, well, that sounds terrible, but that's not going to happen to me. That's going to happen to the people in the next class, right? Well, what is the percent chance that someone's going to become legally incapacitated for 6 months or more during their lifetime, an adult in the United States? What do you think? What percent? 50, that's pretty close. Depending upon who you talk to, somewhere between 45 and 55%. Okay, that's 1 in 2. Flip a coin. You or the person next to you. That's what we're talking about. Let's put that in perspective for a second. Anybody in here play the Powerball? No? Even when it went over $1 billion last time, didn't have the largest jackpot ever just 6 months ago or something? None of you play? Well, then you all must know how bad the odds of winning the Powerball are, right? How bad are the odds of winning the Powerball? 1 in 293 million. They actually got worse about 5 years ago. It used to be 1 in 255 million. You have a better chance of being struck by lightning twice than winning the Powerball. You have a better chance of being struck by lightning while you're being eaten by a shark than winning the Powerball. Every year they come out, they'll be coming out here in about 3 or 4 months. Every summer, there was a shark attack in North Carolina, Hawaii, California, somewhere, right? Florida. And they always come out and tell you, don't worry about it. Don't worry about it. The odds are 1 in 251 million that you're going to be attacked by a shark. Very low chance it's going to happen. Powerball is worse than that. Okay. And yet, every few years, there's $1 billion jackpot. Prizes equal 50% of sales, which means to get $1 billion jackpot, you got to sell 2 billion tickets. That's 6 tickets for every person in the United States. There might be a few more with the stuff going down on the border, but roughly 6 tickets for every person in the United States right now, where you have to be struck by lightning while you're being eaten by a shark in order to win. So I'm assuming if it's a flip of the coin chance that you're going to become incapacitated, everybody in here has got 2, 3 backup plans for that, right? Nope. What percent of people are planning for incapacity? Well, we know 70% of people do no planning at all. Of the 30% that do, less than half are planning for incapacity. It used to be in the 9 or 10% range. Right now, I think it's in about the 12% range, give or take, depending upon who you talk to. So it's up a little bit over the last 20 years. That's good. But it's still 88% of people are not planning for this. Okay. I think that's a problem. Everybody worries about probate. Everybody worries about estate taxes. Everybody worries, are my kids going to get my stuff? And those are all important. But guess what? You're not going to be here for any of those things. Guess what you are going to be here for? Incapacity, by definition, right? You're still alive. You got to go through it. So somewhere pretty high up on the list should be, what happens to me if something goes wrong? Who's going to take care of me? That's part of what we're talking about when we talk about planning for incapacity, okay? And if it's a flip of the coin chance, the other thing I tell people, we were watching the Super Bowl, right? You can bet on everything. You can bet on the color of the Gatorade, how many times Taylor Swift's going to be on, and all those bets, I promise you, are worse than 1 in 2 odds, right? They're not even. It's not bet 100 to get 100 or whatever they talk about. Plus 150, that's the best odds you can get. That means you got to bet 150 to win 100 or whatever. Not good odds, okay? This is flip a coin, so it's pretty serious. All right, so there are 3 main tools that we use in this area. They are wills, powers of attorney, and trusts, okay? Excuse me. I'm going to touch on the wills first. That's the most common tool. How many people have a will? 1, 2, okay, a couple hands. That's the most common tool. Most people who have done planning, and there's another one, Connie and Carletta. All right, so we got at least 4. That's the most common tool. Like I said, they've been around about 800 years. That is the traditional way of doing things. And it is the most common way you'll see even today. Even though trusts are becoming more and more popular all the time, wills are still the most common, okay? Will is the instructions to the judge in the probate court on who's in charge and who gets everything, okay? That's what it does. Does your will avoid probate? No, right? I literally have people walk into my office every single week for the last 29 years, 50 weeks, 50 times 30, that's like 1,500 week, 1,500 times I have people walk into my office. Yeah, I've got my will, so I should avoid probate, right? Nope. Wills are part of the probate process. They are instructions to the judge in the probate court on who to appoint as your executor and who gets everything, okay? And they are part of that supervised process. So wills do not avoid probate. How many wills can you have during your lifetime? As many as you want, right? Which one are we going to look at? The last one you write before you die. And one of the things you'll see nowadays, so when I started, you used to be able to deposit your will with the court ahead of time. Oh, I did my will. Here you go. It's ready to go in case anything happens. About 10 years ago, all the 6 major metro counties in Colorado stopped taking wills until what? Until you pass away. So now if you send in a will, it has to come with a death certificate because they don't want it otherwise. Why? Because all the 6 major counties had these giant warehouses full of old wills that people would deposit one, then make a new one, then make another one. And 40 years later, they said, oh, it's too cold here. I'm moving to Florida. And then they never came back and they died. And there are 6 old wills for this person. And by law, they can't get rid of them. So they had this huge problem of storing all these old wills that were never going to be claimed and never used. And so now they don't take your will unless it comes with a death certificate, okay? And that's when it takes effect, when you die. But so by definition, it's not going to help you while you're alive. People come into my office saying that all the time too. Oh yeah, it's all in my will. It covers everything. Nope, it only covers what happens when you die. It does not cover anything about what happens while you're still alive, okay? By definition. And that means we need a different tool, which leads us to our second tool, and that's powers of attorney. Power of attorney is a document where you give someone the power to act on your behalf, okay? They become your agent, just like a real estate agent or a sports agent or entertainment agent. You give them the power to do certain things on your behalf, okay? For example, sell your house or negotiate your next sports contract or whatever it might be. Power of attorney, okay? You can have power of attorney where you give someone the power to do anything. It's called a general power of attorney. You can do anything I can do. By the way, you can only do legal things. So you cannot go rob a bank and then when the police come, go, yeah, go arrest that person over there. I was doing this as their agent under power of attorney. So they're the ones that are actually the criminal. Nope, you can't do that. You can only do legal things with power of attorney. But you could do anything you can legally do. That's called a general power of attorney. Or you can have a specific power of attorney. And a specific power of attorney you give someone only a specific power. And so the most common example of that would be that real estate power of attorney. If you say, I'm selling my house and I don't want to miss the closing because it's getting harder to sell houses these days, even in Colorado, and I can't be there for it, but we want the closing to happen. So I'm going to give them a real estate power of attorney and say, you can sign my name this one time for this one property on this one day for the closing, and that's it. And then it goes away. Okay, so that's the most common example of a specific power of attorney. The most common ones that I do are a medical power of attorney, who's in charge and what do we do to take care of you, and a financial power of attorney, who's in charge and what do we do to take care of all of your stuff. Okay, but powers of attorney also fall into two other groups. There are immediate powers of attorney. As soon as you sign it, your agent has the power. And there are springing powers of attorney that spring into effect or come into effect upon some condition, like when I become incapacitated. How many people think immediate power of attorney is the way to go? No hands. How many? One hand. All right. How many people think springing power of attorney is the way to go? 1, 2, any other pop-ups? 3. Okay. So I'm assuming the rest of you are waiting for me to tell you which way, right? All right. So I've done about 7,500 powers of attorney in my career, and I've only done 2 springing powers of attorney. Can you tell me why? I don't believe in them and I don't like them. They sounded really good 20 years ago when they came out of the textbooks. In theory, it was a good idea. In practice, this power of attorney is only effective upon the incapacity of the person. That's when you need it, right? What's the problem with those? When you walk into the bank and you hand them a springing power of attorney and saying it's an emergency, I've got to get the money to pay the bills. And you give it to them and they say this power of attorney is only effective upon the incapacity of the person. What do they say? We need proof, right? Yeah. How do you prove incapacity in the state of Colorado? I'll give you a hint. We already talked about it. The documentation of incapacity in the courts. That's right. It's called guardianship and conservatorship. That is the legal procedure for determining that somebody's incapacitated in the state of Colorado. So if the point of a power of attorney is to give somebody the power to help you out so you don't have to go get a guardianship conservatorship, does it help you if you have to go get one in order to activate it? Oops, doesn't work, right? So a lot of times you'll see those springing powers of attorney say you just need 2 licensed physicians to certify in writing that somebody's incapacitated. Anybody ever try to get 2 licensed physicians to certify in writing that somebody's incapacitated? I can tell you, we do it all the time. It's not as easy as it sounds when you just roll it off your tongue, okay? You got to get appointments with 2 doctors, right? I just tried to go in and get my annual physical. How far out did I have to book to get my annual physical? Pretty routine, takes about an hour, nothing crazy going on. How far out? 7 weeks, okay? I hear anywhere from 6 weeks to 6 months. And if you got to see a specialist, it's usually more toward the 6-month mark. And if you're going in because you're incapacitated, who are you going to see? Not the regular doctor. You're going to see the specialist, right? The neurologist or somebody who's going to be, what's going on with you that you can't take care of yourself anymore? So it's going to take 2 appointments, 6 weeks to 6 months to do. Then you got to get them to diagnose you, which means you better not have a good day on the day you go to the doctor, right? A lot of people, when they're getting older, they have diminished capacity, but they're not completely incapacitated. But you don't know what day you're going to get, right? They're usually better in the morning and they fade as they go through the day. Or they have good days and bad days. Some days they wake up, they're great and they're fine. Some days they barely know who they are, where they are, whatever. You have a good day on the day you go to the doctor. You passed all the tests, not incapacitated. That's a problem. You got to get them to agree, and then you got to get them to certify in writing, which they hate doing. Doctors hate these letters. It's extra liability. They don't get paid for them. They don't like doing them. Okay. I've had it take 2 weeks to get the letter after they agreed on everything. They're just not in a hurry to do it. The point being, are you going to have time to run around and do all that stuff I just said if you have an emergency? No, you can't be waiting 6, 8, 10 weeks, 6 months to do all this. You need to be able to do stuff. People need to pay their bills and get medical decisions now, right? Emergencies are emergencies. So the point being, springing powers of attorney, not that great. Of course, about 15 years ago, they came out with HIPAA, which makes it even more fun, right? What's HIPAA? HIPAA is the federal privacy law. It says the only person entitled to get your medical records is you. Every single time you go to the doctor, you got to fill out 15 HIPAA release forms, read all their HIPAA authorization policies, It's 2-3 pages of every stack papers they give you every single time you go to the doctor. It's designed to protect your medical information and keep it safe, right? So only you can use it and it can't be used against you. But with that law, when you go to activate a springing power of attorney, oh, we need proof, right? How do you get the proof? The doctor's got to tell you. But wait, the doctor can't give out the information under HIPAA, right? Until they're authorized. But wait, it doesn't get authorized and spring into effect until you get the information to spring it in. Hey, wait a minute, you can't get out of the circle, okay? You can't activate the power of attorney without getting the information, and you can't get the information without activating it. So it's a real problem. Needless to say, I don't recommend the springing powers of attorney. Last question. What's the point of a springing power of attorney? If you say, I don't want my agent to have the power right now because I'm afraid that they might, what? What do you think they might do? Why wouldn't you give them the power right now? Take advantage. That's right. How do they take advantage? They could take all your stuff, steal your stuff, right? That's what we're really worried about. Or take advantage of you somehow. Guess what? If you think your agent is going to take advantage of you, you probably shouldn't be giving them power of attorney in the first place, right? Oh yeah, I waited 8 years. They finally had a stroke and then it sprung into effect. Now I can take all their stuff, right? No, that doesn't help you. Didn't help you at all. And so I don't think springing powers of attorney work. I don't think they're an effective tool. I don't think they help anybody. What do I recommend? Pick somebody you trust, give them an immediate power of attorney. It's in effect as soon as you sign it, and then keep it in your possession because they can't run around and do stuff with it if they don't have it. It's going to be in the safe, right? What do? Hey, if anything happens to me, you're in charge. It's in the safe, okay? And they go get it. The chances of somebody you trust breaking into your safe in your house to get your power of attorney and take advantage of you, pretty low. And if they do, you didn't do a very good job of picking who you trust there, okay? Because that really shouldn't happen. That's the best thing I've got. If you want to do a springing power, you can. It's just that I don't think they're going to work very well. I've done the two and I put all over the file. I recommended not doing this. I don't think they're going to work. One of the people, they wanted to put it in a little bracelet on their arm. One of those, it was like opening up one of those little Cracker Jack wrapper maps that you get in the box that you have to unfold like 86 times. They were going to carry that on their wrist. And I'm like, I don't think that's going to work. Like the paramedics are not going to search your jewelry to see if it has a hidden compartment and opens up when they show up on the scene. And they're not going to unfold 84 little ripples out into a thing and try to read it. They're just not going to do that. So anyway, there's things that people do that work and don't work. What I try to do for my clients is give what's going to work 96, 98% of the time. That's the best we can do. We're trying to get those odds, just like the Super Bowl, all the betting odds. You want them in your favor as much as possible. Anything can happen to anybody, but that's the goal of the planning. Okay. All right. So we've talked about the powers of attorney. We've talked about the wills. The quote new tool that everybody always likes to hear about are trusts. Okay. And oddly enough, trusts are actually the oldest tool out of all the tools that we have. So statute of wills came 1244 AD. Agency's been around for about 100 years, since about 1910, 1920. Trusts have been around for about 2,000 years. When did they start? They started around the time of Julius Caesar with the Romans, okay? And the soldiers would have to go fight the wars in the legions and go off to Gaul and do the battles and stuff for the Roman Empire. And while they were gone, they would say, okay, I'm trusting my family and my lands to this steward, and that became a trustee. While I'm gone, you are in charge, you take care of my family, and you manage all my assets, and do a good job while I'm gone, because when I come back, if you don't do a good job, I'll behead you or whatever they did back then. That was part of the deal, okay? And of course, sometimes the soldier didn't come back, and so the trustee or steward had to stay on and they were entrusted, and they had to manage everything until the oldest son or someone else could come forward and be old enough to take over. And so those were the first trusts about 2,000 years ago. They have been going on. The most famous ones I know of right now, Shakespeare did one in the 1600s, still going on today, billions of dollars in it. The most famous trust in the world is probably the King's Trust in England, right? So in England, the crown jewels, Buckingham Palace, the Castle of Edinburgh, all those titles and all of those buildings and all of that wealth, which is probably close to $1 trillion, That is part of the king's trust, and you are a beneficiary of that trust as part of being in the royal family. Okay, and then each kid gets kid, grandkid, niece, nephew, whatever they are, gets their various titles and their various stuff based on that trust, which has been going on for like 500 years. Okay, even longer than Shakespeare's. Nowadays, you'll see trusts for the Rockefellers, the Kennedys, the Trumps, the Hiltons. They all have Bill Gates, Warren Buffett, they all have trusts as well. But guess what? Trusts are also a good tool for the regular people, because when you create a trust, you're creating a private contract, creating a plan to say who's in charge, what do we do to take care of me and take care of my assets if I can't do it for myself, either if I become incapacitated or if I pass away. Okay. So if you think about that, if you think about that for a second, it's a very powerful tool for dealing with a lot of the problems we face in this area. The most popular type of trust is what we call revocable living trust. Okay. It's revocable, meaning you can revoke it, amend it, or change it whenever you want. As opposed to irrevocable. Irrevocable, it's irrevocable. You can't revoke it. You can't amend it. You can't change it. And once you put your stuff in, you can't get it back. You've given up control. Only about 5% of all the trusts that I do are irrevocable. The vast majority of people do not want to give up control, and they want their trust to be revocable. Okay. Living trust is by far the more popular trust nowadays. When I started 29 years ago, you could have argued living trust versus testamentary trust. Testamentary trust was usually the traditional way of doing things. It would be out of your last will and testament. So you would pass away, you would have your will. Your will said, when I die, make a trust, hold all my stuff to protect my kids, protect my spouse, protect whoever I wanted to protect, and have the trust continue on after I'm gone. That's a testamentary trust, okay? But that one only comes into effect after you die. So by definition, it's not going to help you while you're alive. As opposed to a living trust, you create it now while you're alive, which means, yeah, we can do all that stuff for after I pass away, but I can also do a bunch of stuff for while I'm alive. Who's going to take care of me? Who's going to manage all this stuff if I get sick and can't do it for myself? So it's a very powerful tool for that as well, okay? Revocable living trust. The cool thing about this, if you make this trust, there are 3 parties to every trust. They are the settlor, the trustee, and the beneficiary, okay? The settlor is the creator of the trust. That's the person who sets the rules. That's the only person who has the right to revoke it, amend it, or change it. The trustee is the manager of the trust. That's the person who's in charge of doing whatever it says in the trust and carrying out the terms. And then the beneficiary gets the benefit of the trust based on whatever the terms in the trust are. Okay, so those are the 3 parties. The cool thing about a revocable living trust is you can wear all 3 hats. You can be the settlor, the trustee, and the beneficiary. What does that mean? Well, if we have Frank and we have Frank's trust, what's the difference on a revocable living trust? Not a whole lot, okay? Who's the settlor? Frank, he can revoke it, amend it, or change it whenever he wants. Who's the trustee? Frank, he's in charge of doing whatever it says to do. So he has the full authority to do everything. Can put stuff in, take it out whenever he wants. And who's the beneficiary? Frank. He gets the benefit of everything in there as long as he's alive. If something goes wrong, other people could take over for Frank and take care of things or get them wherever they're supposed to go. And other people can become the beneficiaries eventually when he's gone. So that's the idea of the revocable living trust. It's a backup plan. You don't have to give up any control. Almost every other tool we use, joint tenancy, different, beneficiary deeds, whatever, you're giving up some level of control in exchange for some other benefit. With the revocable living trust, you don't have to do that. And that's one of the reasons it's becoming so powerful. It allows you to keep control, but at the same time, still have a full backup plan. Who's in charge and what do we do to take care of me and take care of my assets if I can't do it for myself, okay? Very powerful tool. When you do the revocable living trust, you can avoid probate. You put your stuff in a trust. We don't have to get anything out of your name when you pass away. It's already out of your name. It's in the trust. Trusts don't die, so you don't have anything. You don't go to probate. Trusts don't die. They don't go to probate. We don't go to probate. You skip the entire year, year and a half process and the tens of thousands of dollars that goes with it. If you get sick, we've got someone. They can step in, take over managing your assets, use those assets to take care of you. We don't have to go to court for probate, guardianship, or conservatorship. And you can, of course, also have the trust continue on to protect kids and grandkids. Yes, you can protect minor kids, like is the most common way people think about it, but you can also protect adult kids, okay? We all know, everybody's like, oh, 21 is the minimum age, that we just try to get them to 21. Well, at 21, you're just old enough to be dangerous these days, right? Kids run around in their 20s and 30s, they're trying all kinds of stuff. They don't know what they're doing. They don't have the life experience. They don't have the wisdom. They make all kinds of mistakes. If you put stuff in trust for them, they can't lose it, okay? They can get it when it's in their best interest, when it's appropriate. So right now, the over-under for me is around 40 when we give kids their money. Because hopefully by 40, they've got some life experience, a little bit of wisdom. They've picked a family path and it either worked or they got clear. They've picked a career path and it either worked or they got clear, okay? With a 56% divorce rate and an 80% small business failure rate, a lot of kids get wiped out right out of the chute. Nobody says, oh, you shouldn't get married. Oh, you shouldn't start a business. And yet they get wiped out. So when you put stuff in trust, you can protect them. And of course, the biggest thing of all, every billboard, bus, sign, TV commercial, right? Have you been injured? 2.9 million, right? Anybody can have an accident. This protects them from all of those things that they're running around doing in their 20s and 30s with their friends, which they can get in trouble on, okay? Let's see here. Can you designate multiple beneficiaries of a trust? Yes, you can designate as many as you want. It's the same people. You pick the same people to be in charge. You give away the same assets to the same beneficiaries, whether you do a will or whether you do a trust, okay? The will goes to the court, year-long process, supervised by the judge. Trust, private contract, you trust the person you pick to do this without having to have the judge supervise them. Now, if somebody says, hey, trustee's not doing their job, we can always go to court and say they're not doing their job, but we trust they will do it right. And about 80 to 90% of the time, they do. And it saves 90% of the time hassle and cost. Who do you file the written trust with if you don't have to go to probate? You don't file the written trust with anyone, excuse me, other than you would have to address the beneficiaries. So you would have to give the beneficiaries a copy of the trust, give them an inventory of the assets, and then give them an accounting every year. Every year, here's what happened. Here's what I started with. Here's what came in. Here's what I paid out. Here's what's left over. And then eventually someday you would turn it over to them when they reach the appropriate age or whatever event we're trying to do. So that's the idea of the trust, okay? All right, there's lots of things you can do with the trust, but that's the biggest stuff. Let's see, let me touch on a couple of the hot topics and then I'll kind of open it up for questions here. So one of them I've sort of touched on with the kids, and that's the asset protection element. Over the last 20 years, the whole, have you been injured? People suing people has gone through the roof, right? All those commercials on TV cost a ton of money. All those billboards, all those ads, all those bus paintings and everything else. Where do you think they get the money for all that? Because they're suing people left, right, and center, and they're winning, right? So asset protections become a huge element, and we want to protect our kids, not just when they're minors, but all the way up as they're adults, okay? And you can do that as part of this planning, as part of your revocable living trust at pretty much no extra cost. If someone comes to see me to do asset protection, I do it a handful of times a year for the last 10, 15 years. It costs $25,000 to $50,000 to set up an asset protection trust for yourself. It's very complicated. It takes 2 years for it to actually work, and it costs $25,000 to $50,000. You have the ability to give your kids and your grandkids that same protection for free as part of your own planning. So it's a very powerful tool. And it's one of those things, as you watch the world evolve, asset protection is becoming a bigger and bigger thing, okay? The other thing that's a pretty hot topic is the whole long-term care issue. And this is another part of the elder law stuff we do. How are we going to pay if we have to go to a nursing home for $11,000 a month right now? I think Medicaid right now, the average payout's like $9,800 a month. It's about to hit $10,000. And of course, Medicaid is below average. The government, of course, cuts corners and stuff. So they don't always increase like everything else. Same thing they do with Social Security and all the other cost of living indexes. The actual cost that the nursing homes are facing for beds, for food, for nurses, for all the people involved, through the roof, right? And so private pay facilities are more in the $11,000, $12,000 range and up from there. The really nice ones are even more. how do you pay for all that if you have a long-term issue, right? So short-term issues, when you have a health issue, that's covered by your health insurance. When you're working, it's your private health insurance through your business or through your company or through the insurance company that you pay for your health insurance, okay? When you turn 65, Medicare is the government health insurance that everybody gets, and they take over and they pay for stuff. Well, those types of companies only pay for acute care, which is less than 100 days, basically. It's anywhere between 4 and 100 days. And basically, whenever you stop getting better, that's acute care, okay? Long-term care is whenever you stop getting better. Hey, I had an accident. I fell and broke my hip. I had a car accident. I can't walk anymore. I can't do this anymore. I hit my head. I can't remember anymore. And I've rehabbed and done whatever I can do, and I'm back to functional, but I can't do everything I used to do. And if you can't take care of yourself anymore, that's long-term care, okay? And so when they get to 100 days, they're like, that's it. We tried to help you get better. Now it's up to you. You got to pay for whatever you're going to do from here. Sometimes they do it at 10 days, 20 days, 30 days. Okay, we give you 6 weeks when you break your hip. Then you get rehab for 6 weeks, and that's it. You're out. If you want to do more exercises, go ahead. You got to pay for it yourself, okay? So this is long-term care. And long-term care not covered by any of the insurances. If you have to pay for it yourself and it's $10,000, $12,000 a month, that can become a problem really quick. So of course, the government has a welfare program called Medicaid that says if you can't afford to pay for your care yourself and you run out of money, we'll pay for you. We don't want you living on the street, okay? The big thing I tell people about Medicaid, first of all, it's super complicated. We do lots of Medicaid planning. I do it about 20 times a year for the last 29 years. Write a book on it. I think they put that in our materials that you'll get at the end. Every year, I'm actually finishing up the 2024 book right now. Hope to have it out in April or May. It's a real issue. Medicaid, super complicated. That book, 250, 300 pages. You want to, if you're having trouble sleeping, put that next to your nightstand, pull it out and read it when you're ready, and you will pass right out, I promise, within 15, 20 minutes, no problem. It is super complicated, okay? There's a 5-year look-back period, unlimited penalty periods, all kinds of rules you have to follow. The bottom line being, you got to become poor and run out of money in order to qualify, okay? And so for most people, A, you don't really want to go broke. I don't encourage my clients to do that. B, you really don't want to go to a Medicaid facility if you don't have to. Like I said, they only get their $9,800 a month. They don't get the $12,000 that the other facilities get. $2,200 a month, guess where those shortcomings come? You don't get quite as nice a food, quite as nice a beds and sheets, quite as nice a staff. It's just the way it is, okay? So it shouldn't be the goal. But that said, if you think you're going to have a problem covering that stuff, if it's a flip of the coin chance, you want to do some planning. So we do Medicaid planning as part of all this. That's one of our hottest topics as well. And it's one of the first things I have to do when I sit down with somebody. Are we doing traditional estate planning? I'm going to keep all my stuff, use it for as long as I can, and try to pass it on when I die as efficiently as possible. Or am I going to do Medicaid planning? Hey, I think I'm going to run out of stuff. I want to plan to try to save whatever I can so I don't run out and still qualify so the government will take care of me. You can't plan to keep your stuff and pass it along when you die and plan to run out before you die. Those are the opposite direction, right? You can't do both. If you do, you're going to get caught in the middle and you're going to get run over by the train. So the idea is we got to figure out some kind of planning with that. That's one of the other super hot topics over the last 10, 15 years. And it's part of that elder law conversation that nobody talked about 20 years ago. Okay. So looks like we got about 12, 13 minutes left. Let's see here. Someone asked, can you use a trust instead of a power of attorney? Yes. So we use powers of attorney for certain things. There's a few things you can't put in your trust. You can't put your Social Security in there. You can't put your mail in there, stuff like that. Almost everything else you can, but you can't put some stuff in there. And so we do have powers of attorney as part of any plan. So we have a backup just in case. And of course, anything you forget to put in the trust or don't have a chance to put in the trust, we got to use the power of attorney to deal with. But the trust is by far the most protection. It's the most efficient. It's the kindest, gentlest, easiest way to take care of you if you become incapacitated or, of course, if you pass away. Okay. What's the average cost price range for a revocable living trust? So when we do them, they range anywhere from about $2,500 up to about $7,500. I would say the vast majority of people, and it depends on if you're married, it depends on how many kids, depends on if we're doing any special needs provisions, if we have handicaps or anything like that, if we're doing any tax planning as part of it. But the vast majority of people are probably in the 3,000 or 4,000 range for the package. That package usually includes 12 to 15 documents. So it comes out to a couple $100 a document, very reasonable. And when you talk about the costs of probate, guardianship, conservatorship being 15, 20 grand to start each, you get back 10, 20x on your investment, which you can't almost find anywhere. I don't even think Bitcoin anymore, you can get 20x on your money anymore. So very valuable as far as that stuff goes, okay? Other questions, anything that we didn't cover that you came here to hear about? Any questions on anything I did cover that wasn't clear? All right, I'll go through the little spiel here at the end, and then I'll hang around for a few minutes in case you have more questions. So as part of coming to the class tonight, one of the things we talk about when we talk about planning, there are general provisions that apply to everybody, but everybody's situation is unique, okay? And so part of planning is sitting down and saying, okay, what am I concerned about? What are the issues that I face? And then looking at the issues and options and putting those together to come up with a plan on how we can deal with this stuff. And so I've had clients who had 50, 75, $100 million. They're like, I don't care about the estate tax. I don't care if my kids have to pay 55% in estate tax when I pass away. This country allowed me to make $75 million. I don't mind half of it going back. And if my 3 boys get 12 million each, so if they can't make it on 12 million each, they got bigger problems than I can help them with. I had a guy say this, I just want to go ride my motorcycle and do what I want to do and live my life. And when I pass away, it is what it is. Didn't want to do a bunch of planning, didn't do it. So that's that was their goal. I can't make them do it, right? So you got to look at the situation, look at the issues, look at the options, try to come up with a plan. So as part of coming to the class tonight, we've arranged with the credit union that I will waive my regular consultation fee of about $400, and you can sit down with me by Zoom, on the phone, or you can come into the office in person, and we can do about a 30-minute consultation for free, okay? And you can go through all these things we talked about. You can go through your situation, put them together, and see what the issues and options are, and then what the costs of the different plans might be to help address all this. So in the materials Jennise is going to give you, you'll see a bunch of stuff on that. You can reach out by phone. You can go to our website. You can send me an email. Lots of different ways to get a hold of us, okay? I don't have Snapchat or Instagram yet, but we're working on that for you. We'll have that for you soon. All right. What is the 5-year look-back period? The 5-year look-back period, when you go in and apply for Medicaid, when you sign the application, you swear that you have not given away any assets for the last 5 years. And they're going to go look back and see if you did. And if you did, you have to get those back and spend them on your care before the government's going to pay for you. It's a federal felony if you lie about it or get caught, and you can go to jail. Bill Clinton put it in the 90s. It was called the granny go to jail law. And they tried to make it lawyers who helped people plan for this could go to jail too, but that got shot down pretty quick. Okay. But you can still get in trouble. That's what the 5-year look back period is. To help my out-of-state parents, would you recommend finding consult within their state? Yeah. So I can only do stuff in Colorado. That's where I'm licensed. Each state, the laws are roughly 95 to 97% the same in every state. But guess what? Human DNA and frog DNA are 97% the same. That 3% makes a difference, right? And so each state has different rules and different laws. That's one of the things we've designed our country to be that way. Everybody has different potential things they can do. And so this is one of the things you have to deal with that. If you're worried about it, you really want to get someone in the state where you are, because those rules can really make a difference, especially when you get down to the nitty gritty of who's qualifying for what or how the process is going to go. Okay. Most of our family live out of state. Would a living trust or will be recognized out of state, or do we need to update if we move? So, okay, that's 2 parts. So first of all, if family and friends live out of state, you can still have anybody anywhere in the world be a trustee, an executor, an agent under power of attorney. As long as you trust them and you think they can handle the job, they can do it. 90% of the job nowadays is remote, just like we're Zooming here. You can do almost all this stuff on the internet, email, phone, fax, whatever it might be, okay, through the mail or your UPS or whatever. So the most important thing is, who do you trust? You're not going to pick your next door neighbor just because they live right next door to you, right? Oh, I don't know if I even like my neighbor, right? So that's one of the things. On the other side, if you're going to move, you're generally, it's not going to invalidate what you do, but you're going to want to update for wherever you are. So if you take Colorado stuff and you move to California, the laws in California, not 97% the same. They're more like probably 90% the same. There's a lot of differences in California. And if you're in a Colorado, you know, I used to make fun of California. I'd be like, oh, they're crazy out there. They try every new thing, right? Well, guess what? Now they make fun of Colorado. Every time you take a Colorado thing somewhere, they're, yeah, we don't know what they're doing in Colorado. They're all high, right? They're all stoned out of their mind. We don't know what they're doing out there. So they don't like our laws necessarily. And so it's not going to be invalid if you move somewhere else. But you take a Colorado will into a California court, you're going to have a Colorado attorney or somebody who's dual licensed, which costs more money, to tell the court what to do in California because you're under the Colorado probate code. So that can be a problem. So what I recommend, you should be updating your stuff every 6, 7, 8 years. If you move after 3 or 4 years, sometime in the next few years after you move, it's not an emergency, but you should update whenever you're going to update normally. Go ahead and update and make sure you get updated for where you are and where you're going to be. Okay. I will tell you also that of all the documents we talk about, the most portable, the trust. Why? Because we're not going to court. Okay. And it's not going to say Colorado revised statute 400 places like a power of attorney does. It's not going to say Colorado probate code like a will does. Okay. So when you're on a private contract with the trust, trusts are pretty uniform across all 50 states, very similar to, corporate law. That's why you see McDonald's on every corner and Starbucks on every corner. Those corporations can go all over the country and all over the world because their law is pretty similar under corporate. Same thing with trust law. Okay. So of all the tools, the most portable one, trust. It's like your little suitcase or your bucket. You put your stuff in the bucket, you take it with you wherever you go. All right. I got a few minutes left. Any other questions before we wrap up? Okay, well then Jennise, if you want to wrap up, I know you've got some materials you can send out to everybody or post on the website and stuff, and then I will let you guys go. Hope you enjoyed the class. Have a great evening, and hopefully we'll talk to some of you soon. Okay?
Perfect. Thank you so much, Frank. As always, we really appreciate you always breaking down these classes for us. Once again, I do want to reiterate that we will be sending out this recording, and we also will be sending out all the information that Frank discussed, as well as the 30-minute consultation call. You'll get all of Frank's information as well, and that should be out in about 24 to 48 hours, if not sooner. So please be on the lookout for that, but that will go straight to your email. And once again, if you have any questions, you can feel free to email myself or email Frank, and we'll be more than happy to get back to you as soon as possible. Thank you so much for joining us, everybody, and we hope you have a great evening. Bye, y'all.